Okay, good morning, everyone. Thank you so much for joining us for our February Clear Up the Chaos. I'm thrilled to have lots of familiar names and faces joining us. I have Amanda Flynn and Christine Beldner with Ironwood joining us this morning to speak more on the COVID never-ending saga and the vaccines that revolve around that, as well as PTO policies, vacation, and sick leave, and how you might have that incorporated within your organization, and potentially different ways of doing those policies that you might have in place. So I'm thrilled to welcome them, and I'm going to go ahead and hand things over to them to begin. If you would kindly mute yourself so we don't have any issues with background noises. Thanks so much. Okay, I'm going to hand things over, Amanda and Christine.
Thank you guys so much. It's great to be back with you guys. A lot happened right after we got together last month in terms of the OSHA ETS. And so it was really busy that week leading up to it and then right after. So we kind of want to start with a short recap and then walk you through what happened. So remember last time we got together, we did a complete OSHA ETS recap from that November 4th issuance all the way to January 7th Supreme Court arguments. It was super fascinating what was taking place. And then we continued to watch like it was our version of a Super Bowl game, which is coming up this weekend. So we provided our analysis of what the Supreme Court had heard, and we were predicting, along with the rest of the HR community and legal community, that the Supreme Court was likely going to rule on January 13th. And the reason why we were all speculating that is the Supreme Court updated their website and put this out of cycle update to their calendar saying that they were going to release opinions on the 13th. So we sat in anticipation, and the 13th morning came and went, and they released information about the Social Security Act, and we all just kind of died a little bit on the inside and wondering where it was, because we were just waiting and standing by. But perhaps the Supreme Court showed their sense of humor, because they did release their ruling later that day. And just kind of wanted to walk you through what it means, what they actually spoke to in their ruling. So they did grant the petitioners that emergency relief with a 6-3 ruling, which is actually what Ironwood theorized how it would kind of fall out. So it was really interesting to see how watching the arguments actually transpired to how it was actually ruled. So that was pretty telling. But let's walk through kind of the highlight, the main points of what the Supreme Court said and their position is. So generally, OSHA regulations must be reasonably necessary or appropriate to provide safe and healthy employment. And they have to be developed using a very rigorous, distinct process that allows for appropriate time for notice and comments and a public hearing. The OSH Act does allow for those ETS exceptions, and I'll speak to how many there have been in a short time. And those give those exceptions to those ordinary procedures. So it is within OSHA's purview to release those emergency temporary standards. However, to be a valid ETS, it requires a grave danger to employees. And I don't know if you guys are kind of following it, but this grave danger definition is primarily where the legal community really judged the weak point of the ETS was at, and it was really analyzed. So to be a grave danger, it has to be, for example, something that is like a toxic substance, physically harmful or a new hazard. And 2, then an ETS has to be deemed necessary. Okay, so that's kind of the burden that OSHA had going into this ETS, and at the crux of the whole entire argument, what the Supreme Court had to analyze and determine if those two burdens were essentially met. So the court reasoned that although OSHA can regulate a workplace safety standard, this particular ETS, as it was written, reached beyond that and really ventured into territory of more of a broad public health measure. And that's where you can see it starting to fall apart in the Supreme Court's ruling. So further on, the Supreme Court actually states that the ETS would be a significant encroachment into the lives and health of a vast number of employees. And again, it's probably worth saying, I'm not trying to pull these points as an ironwood position, but these are directly from the Supreme Court opinion. So a lot of the things I'm quoting direct from what they actually ruled on. So they went on to say, although COVID-19 has the potential to affect all employees, they did not deem it an occupational hazard or a grave danger that stems from the workplace. The court said that it's spread anywhere people congregate. It's likened to the risk of day-to-day dangers that all face from crime, air pollution, or any number of communicable diseases. So again, that kind of gets you into the mindset of where they were ruling. However, the court did go on to recognize that OSHA does have the power to regulate specific occupational risks associated with COVID-19. So, for example, OSHA would have the authority when a particular function of a job would place employees in special danger. So think about those researchers actually working with the COVID-19 virus, right? The Supreme Court did rule that it would be appropriate for OSHA to regulate those type of environments, or especially crowded or cramped environments, so that they did leave these small caveats of when OSHA would have authority and would be able to provide some regulation in some context. So, however, the Supreme Court ruled that the application of that particular ETS, again for large employers, that 100 employees or more, application to all industries in such a broad swath exceeded those general public health measure requirements, and again, what the intent of the Occupational Safety Health Act is all about. So, and then finally, the court said, look, this particular ETS really lacked precedent. And as I mentioned before, there have been 9 previous ETSs issued by OSHA. None were this broad. And so the Supreme Court was pointing that out. 6 of those ETSs in history were challenged, and only 1 was fully upheld. So I think we all kind of knew going into this is OSHA, the government, had a pretty significant hill to climb. And so that's how it fell out. That was the high points of the Supreme Court's opinion. So what's next for OSHA following that? And it's interesting how this has already evolved since that initial Supreme Court ruling, because initially, then the community just started jumping on what can OSHA do. What they theorized is basically there were 2 paths that OSHA could take. One, they can move forward with a permanent rule, so not an emergency standard, or they can begin to work COVID compliance through that already existing general duty clause. And what we saw was when the Supreme Court ruled, basically they sent it back to the Sixth Circuit Court of Appeals to make a determination. And what the community kind of anticipated is that the Sixth Circuit Court likely was not going to move with any kind of speed, because the ETS was going to set to expire May 5th. And so the Sixth Circuit likely was just going to sit on it based on what the Supreme Court opinions was. So then I think it was a little bit surprising. OSHA released a statement January 26th. So this 13 days after that Supreme Court rule, saying, look, we're withdrawing the ETS as an ETS. And I think there was some interpretation originally thinking that this was, if you're anti this ETS, to your favor. But OSHA went on to say that, in fact, they're not walking away from it. They were basically stating that their plan was to move forward with that permanent rule. So it was one of the two paths that the community kind of anticipated OSHA would be able to take, and that's what they began to communicate. Well, what does all this mean to us as employers? I think we're as equally confused as we were November 4th when the ETS was released on which path to take, especially because now OSHA has teased that, look, we plan to continue this fight just in a different way. Honestly, we don't know yet. There are probably some great writers and legal scholars working with OSHA to kind of draft their plan, and we're waiting to see what OSHA communicates. OSHA could look at combining the various ETSs into one permanent rule. Of course, OSHA could also present each ETS as its own distinct permanent rule. All that to say, no matter what route OSHA takes, we expect those permanent rules to be challenged, much like the various emergency standards were challenged. So meanwhile, there was a lot of news, probably of less notoriety of the various other ETSs. And we know that NCW and Sanford Tatum have a wide variety of industry clients. So we wanted to kind of update all of the other ETSs and where they're at just briefly. So the Executive Order 14042, which was that federal contractors ETS, also was officially paused December 17th, 2021. There were several more appeals being fought, and so the Biden administration notified federal contractors that it will not enforce the requirements of that executive order. Same thing with the executive order for federal employees, January 21st. Again, it was blocked by the Federal District Court in Texas. This ruling is pending a Justice Department appeal, but again, the government has come out, Biden administration has come out and said that with the preliminary nationwide injunction in place, they're going to take no action to implement or enforce those requirements under Executive Order 14043. And again, that's the one for federal employees, which I doubt we have on the call today. But if you have colleagues or friends, they would probably appreciate that update if they're not already talking about it themselves. We have a couple links of these various updates that we plan to send you, Elizabeth, after, and you can disseminate as you wish. Healthcare workers, a little bit different update for you in that the Centers for Medicare and Medicaid Services, they did issue back in November a vaccine mandate, and that case was also heard the very same day of the large employer ETS, and the Supreme Court did permit that interim rule to move forward and enforce those requirements. So based on this decision, covered providers are now subject to 3 different key compliance deadlines depending on their location. Texas has a February 22nd and March 21st deadlines for policies and vaccinations respectively. So we'll also send out a link to more information about that. So again, that applies to those healthcare workers as defined by the Center for Medicare and Medicaid Services. Okay, so the bottom line, the big question, what are we to do as employers besides just continue to sit and wait and wonder? Private employers can still require vaccinations so long as your companies are not in states prohibiting these requirements. So we know here in Texas that Governor Abbott had issued his own no private employer will mandate vaccines, so his own order. So you have to make sure now that you're paying attention to those state orders that have been issued, but you can still, if you're not in one of those states, require vaccinations. Of course, Amanda and I, along with the rest of the HR community and legal community, are kind of watching what those large employers that were, if you will, first in line to start the vaccine mandates. And we're noticing, while it's gone pretty quiet, many are pulling back their requirements of the vaccine mandate. That can be misleading. So yes, we're hearing about those companies that are no longer enforcing the vaccine mandates, but that also means the companies that are still requiring it, they're just not speaking up. They didn't have a change in their policy, so there's no news to announce. So that can be misleading of it in and of itself. So, but we're still monitoring that. We're watching the trends. What we would tell everyone on the call today is we just encourage you to continue to be in consultation with your legal counsel, your leadership, your HR team with Ironwood, with Elizabeth, to continue to formulate your position. And as we mentioned in prior calls, we did develop a resource site. On there, we dropped, since the Supreme Court ruling, an updated template letter that employers can use to send out to your employees, giving them an update of the Supreme Court ruling and where you can articulate what your company is currently doing, what your current position is. And we couldn't say it enough. Communication is always key. We're big advocates for employers being transparent with their employees. And this is a great opportunity to continue that conversation. And it's okay to say, we're watching the government. We don't know yet, but right now, this is our path ahead. I know coming into the call today, we did have one question. And this is not a unique question to this particular business. A lot of employees are familiar with the fact that there was a period of time where COVID-related leave was, employers were receiving that reimbursement up to 80 hours of the employee's leave to supplement that time away. That went away in September of last year. And it left almost in a way some awkwardness. So employers had put in these policies, especially small businesses, knowing that they would get reimbursed, that they would cover those 2 weeks of COVID related leave. And then of course, when that reimbursement stopped, small businesses were in a position where they had to make a decision. Can we continue to afford this now at our own cost or not? And so, you might be wondering, as a small company, how can you navigate this now that you're not getting this reimbursement from the government? So again, as we mentioned about where the ETS stands itself, communicate. Put in your temporary policy, your permanent policy since that leave benefit expired, and let your employees know that as of today, or perhaps January 1st, or whenever you started implementing, saying that we could no longer cover this additional COVID-related leave, that moving forward, what are the other options the employees have, and communicate that, whether that be the employee could use their existing PTO balances, their employee can use their vacation balance. Perhaps you're going to offer leave without pay up to a period of time. And then again, you have to take into consideration your FMLA eligible employers and what you're going to do there. So again, we would communicate what you want your policy to be, but you have no obligation, again, to provide 2 weeks of paid related COVID leave any longer. And that brings us actually to Amanda, because it's all the questions that we've been receiving at Ironwood since the start of the year have really been about this very situation, and how employers can adapt their vacation and PTO now that there's been so many changes. Amanda?
Thanks, Christine. Like Christine said, we have been getting just a lot of calls about different PTO, vacation, sick time policies. And again, some of them were very COVID specific related. And a lot of them were just fresh beginning of the new year. It looked like people were getting out their handbooks, starting to look through their policies again, seeing if that made sense, last year's plan or any previous schedule. So we'd had quite a few questions, and I wanted to cover some of the big key tips and components that we get the most often. I've talked to several of you guys. It's so nice to get to see so many NCW and Sanford Tatum names that I recognize and I've talked to on the call. I will say that the key points that I'm touching on today is we are keeping it pretty broad because there's a lot of different size companies and a lot of different industries on the call. I'm also mostly specifically talking to Texas law. These rules are often different state to state. So if you've got employees in New Mexico, you've got a sick time law coming this summer. If you've got employees in Colorado, there are already sick time mandatory pay in place. Excuse me if I could talk. So for the general conversation we're having today, we are talking about here in Texas, not just that you are based here, but all of your workers work here. So just wanted to say that generally up front. If you have been managing leave for your company or this sort of vacation or PTO or sick time policy over the last few years, you might remember that back in 2019, there were quite a few different city ordinances that went through. Dallas, San Antonio, and Austin. Each of those cities had put forth legislation that summer that went into effect requiring sick time. And it was a very specific scale. I know for Dallas in particular, I believe San Antonio and Austin was set up the same way, but it was, you had to give 1 hour of sick time for every 30 hours worked within the city. So it was particularly fun if you were working at that time and had employees in different areas of town in and outside of those major metropolitan areas to figure out how you were going to navigate that. Since that time, all of those laws ended up being paused. And so none of those are still in effect now. So if you redid your leave policy back in 2019 when they briefly went into place, it might also be a good idea to think about what you want to do moving forward. And then I'll throw one more exception at you here as we're talking about generalities. There are a lot of different asterisks and exceptions as far as leave policies go, especially when you start talking about FMLA. If you are a large enough employer that you've got employees going out on that type of leave, there are some different rules in place that you want to be mindful of. Same if you are talking through a workers' comp issue, military leave, any of those protected by law type of leave situations that we would want to dig in a little bit more and get the specifics about before applying some of the things that we're talking about. So to start, the number one question that I get is, are we required to provide anything? So here in Texas, you are not. There is no rule, legislation, nothing in place that says you as the employer have to give either your employees vacation time, sick time, or if you went into that general paid time off bucket, that could be either of those times. There, again, no rule necessarily defining that you have to give those. I'm going to speak to this a little bit later because I feel like there's almost a little bit of an asterisk about sick time here, but when you get into the weeds about how you deduct from salary employees. So we'll touch on it a little bit later. But in general, there is no specific rule in place that you have to provide any of those things. The key tip, if you take nothing away from today other than this, is you need to have a written policy and it needs to be applied consistently. When you think about vacation time, PTO time, sick time, Remember that we are talking about employees' wages, employees' salaries. There are not only numerous laws to protect individual employees, that they be paid for hours worked and anything you have in place. There's all sorts of checks and balances. It's also going to be something your employees are going to notice. If you update your IT policy and now there's a minor change and sure you announce it and everybody signs up on it, it may not affect 100% of your employees day to day. But if you start doing or making changes that affect someone's paycheck, you better bet that someone is going to notice that. So again, have a policy, have it applied consistently. And we're going to go through some of the components, but that's the biggest situation. Several of you guys, or a few of you guys that I've talked through in writing actual policies, or if I've worked with you on a handbook, I'm asked often, can we put situationally on a case-by-case basis? And I understand where employers and companies are coming from it, and knowing that there's so many things that can happen when you start thinking about paying out PTO or whether those rules and regulations apply. Again, when you're speaking about paying out PTO, you really have to do this consistently. You could go in and define, if an employee leaves in good standing, we are going to pay out any accrued vacation time. And then you would go on to define, here's what good standing looks like. And it could be components like not on any sort of performance plan, not in any employment discipline process. Did they give the adequate amount of notice that you would like before someone resigns? But that payout piece, there's so many ways that if you do that on a case-by-case basis or inconsistently, that even if it is not your intention, it could appear to be discriminatory. You really have to have policies. Now, that being said, it is entirely possible that different business units within your company might have different policies in place. It is entirely possible, and we got this question beforehand, that you have a PTO. I'm going to start using PTO in general. I'm talking about vacation and sick too, but that you have a PTO policy for your exempt salaried employees. So these guys that aren't necessarily only working 40 hours a week, that aren't entitled to overtime, and then your non-exempt, probably hourly employees. You can have separate policies. Again, it would need to be laid out that way. You need to make sure that your employees are aware and understand the policy. And again, you need to follow it consistently, each and every time for whatever you determine for those guys, especially your non-exempt hourly employees. Again, there are many more specifics when you start getting into wage and hour laws as far as your hourly employees being paid. You have a little bit more leeway in negotiating with salaried employees. Again, we would want to deep dive look into something like that. But sometimes, since it's included within their compensation package, there is some room for negotiation there. But again, you start getting into those situations where you want to have these one-offs or have a strategy that has multiple levels. It would probably be a good idea to go ahead and give us a phone call and let's chat about it and talk through some of these one-off possibilities. So again, you want to make sure whatever you decide that your employees are fully aware of it. And it's one of the first questions a lot of times that employees ask when they are either interviewing for your job or they are on their job for the first day. You also really want to make sure that your supervisors are trained and understand that, because as executives or leadership or as your HR, responsibility department, you guys could come up with this beautiful, wonderful plan that is clearly laid out and defined. But if your supervisors don't completely understand it, it's going to be impossible for them to apply it. And again, that kind of can get into that nuance that, of course, your supervisors can read a policy and understand it, but you start getting into all of those little situations. So many of us had to pause business or change our strategy last week when we shut down for weather. You know, that's one of those nuanced things that you would have really wanted your spokesperson, your supervisor to understand how to address that and how your PTO could possibly have been applied to those days for those hourly employees. So you want your supervisors and managers to understand the policy so that they can answer questions and work with their employees. It's also possible that some of the timing or individual rules could be defined by a department. It's possible if you think about your AR or AP or your accounting department, that there might be rules as far as you can't take off, you know, these 3 days at the end or the beginning of a month, or if you have a really specific business deadline, a lot of times you'll see blackout dates that employees can't take PTO on. Again, you are within your rights to set those dates, but it's about defining it, writing it out, and clearly communicating it to your staff ahead of time with plenty of notice. Because if you are going to provide them PTO, you need to give them the opportunity to use it. So they need to know that there are going to be either days or times of the month or times of the year when it's going to either be a complete blackout on PTO or very limited levels of approvals. So when you are sitting down, analyzing that policy, you are going to want to define those time periods where any of those types of leave would be restricted, or if it's restricted to a certain number of people. So that could be only one person in the department is out at a time. It could be something like only one person in an individual role could be out at a time. If you have multiple people, you always want to make sure that you have someone that can do that person's job. So you may have trade-offs between different shift members, and it may not be one, it may be a larger department and 3 employees can be out, but we have to have 3 people to cover those. Because you always have to keep those back of the mind scenarios in place too, that you have to continue business. If you gave 3 people the day off to go on vacation, entirely scheduled, that doesn't mean a family emergency may not come up for one of the 3 guys that you were counting on. So you really want to think through these scenarios and not just decide to wing it that day, because we all know how that goes. You want to have a plan for these types of things. So another key component that you would want to make sure is outlined in your policy or in your internal procedures is how individual employees request leave. This could be an automated system if you have either some sort of HRIS system or electronic timekeeping program. A lot of times those have mechanisms built in where you can automatically go in and either request vacation, PTO. Heck, it even has jury duty, bereavement, holiday, training days if you offer those things. But that's not going to apply to everyone. It's wonderful if you have that software that will allow your employees to go in, directly request it, have it sent to the supervisor and approved, and send a message back. That's great. If that's your procedure, though, make sure everyone understands what that is. So that also includes the timeline. If you need a week's notice to be able to plan to cover somebody's shift, you need to say that. If you need 24 hours notice, if you need 3 days, whatever is reasonable for you. And then a lot of times businesses will also put a note in there that if you need more than a week off, or you're going to take a full week off. An employee wants to go out of town, big vacation, and they're going to take a full week off. It's fine to say, okay, for a regular day off, I need 3 days notice. If you want to take 5 business days off in a row, I need 2 weeks notice. I need 30 days notice. It's fine to ask for that so that you can plan to run your business while this employee is out. And you'll have to determine what those timelines are for those scheduled absences. You also want to think through and have it defined what your process is. How are you going to approve that time off? We do get questions a lot of the time about whether you can deny a day off request. And you can. Again, that's another one of these caveats you want to think through. And you are going to know your people in your department about what would happen if the PTO day was declined. Are they going to turn around and call in sick? You're going to have to think through those sorts of things, but you certainly can deny it. You want to lay out, especially if this is not working the way that you would like it to work right now, ideally, that it is a request for time off, that you may not always be able to accommodate all of the employees that want to take off at the same time. You know, so many people want to take the end of the year off if they celebrate Christmas or other holidays at that time. You may not be able to allow everybody to have that time off. And same thing happens spring break, especially anytime kids in school districts are out. You may have to put in those limits, which is why if you've got that clearly defined procedure in place about how many people cannot be off or what the coverage requirements are, you have that laid out. But within that approval process, if you're going to follow a standardized method as far as we approve vacation requests for these high demand times by seniority. So whether that's time with the company, another way you might see it is a first come, first served days off type policy. I've seen both. I've also seen a lot of places where they didn't specifically outline that, but then within the departments, they really wrote out that process again, so that everyone was informed, everybody understood going into it, you know, how it worked. But if there was some of those tricky components about coverage and things like that, if there was a specialty way that they were going to handle requests, that would be written at the department level. But most of the time you see a seniority-based program or a first come, first served. You even might have language in there, especially if you have first come, first serve, about how far in advance you want them to put those requests into place. Because I can't imagine I'm the only one on the call who supervised a group and it was a first come, first serve, and people would put in for Christmas on January 2nd when we got in the office. And we didn't know what was going to be happening. It was impossible as a employer, as a business, to know what the situation was going to be like at the end of the year. So you could say requests should only be put in within 90 days. Again, I'm kind of going through some of the one-offs here because those are the types of calls that we generally talk through with you guys. But it's fine to put those sorts of rules in place. Just make sure they're laid out. Another component of your policy that you want to think about is whether or not you will automatically deduct from that bank if an employee has an unscheduled absence or if they don't specifically request that time off. So this is those situations where they call in sick or there was a family emergency. It wasn't this pre-planned day off. And sometimes you'll have employees that are asking you, you know, can I save my PTO because I want to go on vacation later and just take some unpaid time off. So you want to clearly state in your policy something to the effect of, you know, even if you do not request paid time off, it might be applied to your schedule, or I'm coming up obviously with not perfect language there, but some sort of language in there that it will automatically be deducted for absences, or that all paid leave must be used before any sort of unpaid leave were to come into play. So things to think about there. Another big piece that I would encourage you to think about as you are developing these policies and processes and procedures is what is realistic for your company. I touched on it just a little bit if you have an HRIS or an electronic system that does this, but if you are not also the accounting department or a supervisor that would be tracking this, this is where you're going to want to pull in some of those people to help form this policy, because what are the logistics of keeping up with this? It's great if you have a policy, but if there's no reasonable way to track it, or it's going to become an hour of work every week for the supervisor to do some sort of really complex spreadsheet or file a report or whatever the case may be, we want to be realistic. That's also going to come into play when you are writing these policies and thinking about whether or not that PTO bucket of hours, let's say, if you are giving some, when that's going to reset. Again, the most common things that we see are that timeline resetting either on the calendar year. So someone, January 1st, you have 80 brand new hours that you can use throughout the year. Or a lot of times you'll also see that timeline resetting on anniversary dates. And there are pluses and minuses to both of those. What's nice if you're able to go by an anniversary date year is you've got this staggered timeline. Not everyone is going to be rushing to use their time. December 1st, oh my gosh, we have half the staff still has a week's vacation and there's no way we can accommodate that. And then you get in that tricky place where you want them to take their time and use their time, but you have to be able to continue to run your business. The piece that becomes more challenging there is can your tracking system keep up with all of those different anniversary dates? Especially if you throw in a component where perhaps an employee is on an introductory period, their first 90 days. So maybe they're not eligible to use the time for a certain amount of time. Or if they are accruing a certain amount of hours per month. You've got to think about how is the accrual part going to be tracked and how are the deduction pieces going to be done. And then as you're going through that, building that process for requesting, your tracking and accounting piece, then that could include creating some sort of written time off request, or you could put it through and make a fillable form through Adobe, even if you didn't have a full electronic system. But again, it's going to need to adapt to what's easiest for your workforce. But that's also something you want to think through is what is this exactly going to look like? Are there approval components on there? Are the employees signing and dating them? Making sure that you have something created for whatever process and procedure you determined that you were going to follow. So again, you could put the amount of notice required into the policy. If you do come up with a PTO form, one of the things that we request form, one of the things we recommend is putting a little reminder there at the bottom. You could put a bullet point reminder of the whole process if you had space for it, but especially that we need 3 days notice for any vacation request. We need 30 days notice for any 5 business days or more, or anything if you are requesting 2 weeks or more, we need executive level of approval. Whatever those caveats are that are necessary and important to business that you really want to remember, you can put as a little reminder note there at the bottom. You also want to think about what increments you are going to allow your employees to take that time off. What is most common for your hourly employees is things as small as 15-minute units of time. You know, if they need to take a long lunch break and instead of taking 30 minutes, they need to take 45 minutes to run an errand, having them request that and take those in 15-minute chunks. And again, I normally recommend 15 minutes being your smallest unit of time. Again, because think about those logistics of, are you going to apply 8 minutes at a time if they come back? Think those sorts of things through. Now, you'll notice that I talked mostly about hourly there, because when you are thinking about your salaried employees, those exempt employees, you have to start considering all of the different requirements that are in place for how you can deduct from an employee's salary. There are some very specific components. So a lot of times with exempt employees, you'll see employers requesting that they ask in either half day or full day increments. A lot of times really preferring full day. There's only very specific reasons that you could deduct a full day of pay from a salaried employee. Again, unless you're in one of those leave situations, one of which is being out for a full day. So if your employee, let's say, burns through all of their PTO, they're salaried exempt, and they need to leave at noon on Friday because their child's sick and they have to go home, they have no PTO. You would still pay them for the rest of that day, because again, we're getting into these logistics of salaried and exempt, but you know, they are paid based on a project, based on a job description, based on a duty. If they have PTO, you can certainly go ahead and apply it, but you couldn't deduct for less than a full day unless there was one of these other legal protected time off FMLA type situations happening. That being said, the one thing I told you I was going to circle back to at the end is this fun exception from Texas payday law that you have to have a bona fide sick leave policy to deduct days of pay from salaried employees. So what that means is you have to have provided 5 days off over the course of the year. It could just be that PTO bucket. It doesn't have to specifically be sick time to your employees to be able to deduct a day, again, a full day, because an employee is sick. They want off to take an additional vacation, personal reason, not medical at all, you could deduct a full day pay. But if it's a medically related reason, you have to have that bona fide sick leave policy in place. So those are the main points that we want to talk through. I did see one question pop up about holiday leave requirements. It would be a similar situation. There isn't necessarily any laws in the state that say you have to pay your employees for Christmas Day, for New Year's Day. Nothing that you have to. Again, you're going to want to treat it the same way, have a policy, have it clearly defined and communicated, and follow it. Because that's another situation where you may be looking at changing somebody's pay, whether or not they work X amount of days in the pay period or not. You're going to want to know whether or not that is going to apply to you or not. So that is actually the end of our main points that I had for you guys, but we bet that there might be at least one question about some of the things that we cover. So we'll check back with Elizabeth.
Thank you all so much. So I will open it up for questions. If you want to send any questions via the chat box, that's a great way that I can relay those questions over to Amanda and Christine. I do want to remind everyone, as a client of NCW and Sanford and Tatum, you do have access to these wonderful ladies in Ironwood at any point in time. During the week, the year, you don't have to come through me. Once you've signed the paperwork, you can go directly to Ironwood and their team for guidance. So if you haven't filled out that paperwork, I highly encourage you to do that. And I will send that paperwork over in the follow-up email. So I do encourage you to take the time to fill that out. Okay, we do have a question. If an exempt leaves 2 hours early, I assume you still don't have to dock their pay.
That's correct. You can't dock their pay. You could apply PTO if your policy allowed for that level, but you couldn't dock their pay for that. And again, unless it's FMLA, workers' comp list, one of these asterisk situations that is happening.
Perfect. Do we have any other questions while they're on? Okay, well, if anything comes up, feel free to shoot me an email and I'm happy to get them the question and get you an answer. Just a reminder, Clear Up the Chaos does take place the second Tuesday of every month. So if it's not on your calendar, we would love for you to add it and join us and become a regular. So the next Clear Up the Chaos Save the Date is Tuesday, March 8th at 10 a.m. I hope you all have a great week. And if you need anything, please feel free to reach out. Thanks so much.
Thank you.